this time, I would like to call this meeting to order. Today is Thursday, November 10th, 2022, and this is the meeting of the Rent Stabilization Commission for the City of West Hollywood. First, I would like to acknowledge that the land on which we gather, currently known as the City of West Hollywood, is the occupied, unceded, seized territory of the Gabrielino Tongva and Gabrielino Kij peoples. Commissioner Maggio, would you like to lead us in the pledge?
I pledge allegiance to the flag of the United States of America and to the republic from which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you all. All right, Ms. Secretary, may we have a roll call, please, at this time?
Commissioner Kerpes.
Here.
Commissioner Maggio.
Aye.
Commissioner Martz.
Present.
Commissioner Montemayor is absent for tonight. Commissioner Wright will be joining us shortly. Vice Chair Ayers.
Here.
Chair Topshin.
Here. We have a quorum. Thank you. All right, Commissioners, approval of agenda is the next item, and I'd like to I would like to note that the the appeal application D-4674 has been withdrawn. And with that, do we have a motion to approve the agenda?
To approve.
I'll second.
All right, we have a motion and a second. May we have a roll call, please?
Commissioner Kerpes.
Aye.
Commissioner Maggio.
Aye.
Commissioner Martz.
Aye.
Vice Chair Ayers.
Aye.
Chair Topshin.
Aye, motion passes. Thank you. Okay, next is approval of minutes of the October 27, 2022 Rent Stabilization Commission meeting. Commissioners, did you have a chance to review the minutes?
Move to approve.
I will second that.
We have a motion and a second. Ms. Secretary, may we have a roll call vote?
Commissioner Kerpes.
Aye.
Commissioner Maggio.
Aye.
Commissioner Martz.
Aye.
Vice Chair Ayers.
Aye.
Chair Topshin.
Motion passes. Minutes are approved. Thank you. Do we have public speakers tonight?
No public speakers at this moment.
Okay, so then we'll move on to the manager's report. Rent Stabilization Manager, Mr. Jonathan Hollop. May we have your report?
Of course, thank you, Chair, Vice Chair. Good evening, Commissioners. Jonathan Hollop, the Rent Stabilization Manager. So first of all, just to note that this meeting will adjourn to a special meeting rather than the regular scheduled meeting of December 8th due to a conflict with city staff not being able to make it. So the special meeting will be held on Wednesday, December 14th, 2022, and we've polled the commission and we will have a quorum. So the appeal scheduled for that day will be D4689 and the increased case I-152, both relating to the same property. The eviction report that I've received for the month of October from Betzetic has 12 cases for that month. So it's a few cases from the last report, but holding relatively steady. I reported last time that there had been a federal district court injunction of a portion of the tenant protection resolution that the county enacted. It related solely to the provision regarding the ability of a tenant who is at or below 80% of the AMI to self-certify that they can't pay rent due to COVID-related reasons. The court delayed the injunction until December 1st, recognizing that the impact it would have and also giving the county an opportunity to correct what the court found to be the problem. I did check the Board of Supervisors agenda this morning, and there is a correction on the agenda for the 15th. So hopefully that will pass and the status quo will remain. And that provision will be in effect as expected through the end of the year. I wanted to note that a letter will be going out from the division in the next week or so to the property owners of non-rent stabilized properties regarding the upcoming requirement to register and re-register non-rent stabilized tenancies that this commission reviewed and that the council passed in February. That requirement will go into effect at the beginning of the year, and just so folks know, it's going to all for-profit, non-rent stabilized, multifamily residential rental properties, which is all properties that receive their certificate of occupancy after July 1st, 1979. And the amendment to the RSO also includes condominiums and single-family homes that are being rented. So people who own those properties will receive this letter. I want to make it clear to them, and it's very clear in the letter, that if you are not renting your property, you do not have to comply with any registration requirements at all. But if you are renting your condo or your single-family residence, you will. And this is an initial letter, just letting people know it's coming. Another letter will be coming in the new year that will explain exactly how to register your property through the city's online registration and re-registration system. On November 7th, the council passed on second reading the end to the rent freeze, which will be effective March 1st, 2023. The council also passed the 3% cap of the AGA. So the division is also sending out notice of that to all rent stabilized property owners and tenants, along with to the property owners the most up-to-date notice of rent increase, which is something we had always done prior to COVID in our biannual newsletter. So those are the things that people should expect to see very shortly. And I'm available for any questions.
Thank you, Commissioners. Commissioner Corpus.
I just have one question about the property owners receiving the registration forms. Does that include, or what if somebody rents subleases or sub-rents in their, has a roommate basically? They own a home and they have a 3-bedroom and they rent out 1 bedroom. Do they have to register?
No, that would not be required.
Thank you.
Other commissioners? All right. If no follow-up questions to the manager. Commissioners, this is our time. If you have any comments at this time, any commissioners would like to make any comments? Commissioner Corpus?
I just have one announcement. The office, as many of you know, I work for Assemblymember Richard Bloom. On Wednesday, November 16th, we'll be hosting a webinar on understanding the eviction process, knowing your rights. It'll be 5 p.m. on November 16th, and you can access information at asm.ca.gov/Bloom, B-L-O-O-M, and there's information on our website about it to register.
Thank you. Other commissioners? I don't see anyone would like to make any announcement or comment. We're going to move on to our appeal section of the tonight's agenda, and we have before us the appeal application D-4687, which pertains to the property address 605 North Switzer Avenue, and this has to do with the reduction of housing services. First, I'd like to
Chair,
check if...
do you mind if I jump in real quick? I guess it was announced earlier that Commissioner Wright might be coming soon. I just want to advise the commission that you don't have an obligation to, but for due process purposes, as soon as the hearing starts, if Commissioner Wright isn't here, they won't be able to participate. So I don't know if the commission wants to consider a recess or if they're fine with going forward.
Okay,
Just letting you know.
Okay, thank you for that. But typically, I don't like doing this because the commissioners and the parties, they don't have to wait for someone who is not here on time. But
I did get a text, Chair, that she would be 10 minutes, but I think
what time is it now?
it's just about that right now. Why don't we allow at least 2 or 3 more minutes?
Okay, so we can take a 5-minute recess, and we'll be back in 5 minutes. But that for the future commissioners, just please keep this in mind. Thank you. All right, this meeting is back to order. Please be acknowledged that Commissioner Wright joined this meeting at 7:16 p.m. All right, so we are at the appeal section of this meeting, and as I said, this appeal has to do with the reduction of housing services. And first, I'd like to check if the parties are present at this time, Ms. Secretary.
Yes, both parties are present in person.
All right, that's great. Thank you. So before we begin, I'd like to take a minute and to explain the process for the appeal. First, we will hear the staff report presented by the legal counsel, Mr. John Natalizio, and then the appellant, which in this case is the property owner, will speak first and will state how the appellant would like to divide the time. Each party, I want to mention that each party will have 5 minutes, and the appellant has a choice to divide the 5 minutes between the presentation and the rebuttal. And the respondent, that would be the tenant, in this case, will speak second, and the tenant will have only 5-minute segment to state the case on the appeal subject. And when it's time for you to speak, please come forward to the microphone, state your name and the city of residence for the record. And as I said, the appellant will indicate how the 5 minutes will be divided, if any. And make sure that you, during your comments, you will stick with the original issues and items discussed at the hearing. No new evidence or information will be considered by this commission. And with that said, legal counsel, may we have your report?
Thank you, Chair, and good evening to Chair, Vice Chair, Commissioners. My name is John Natalizio. I am the legal counsel to the Rent Stabilization Commission for the City of West Hollywood. This appeal was filed by Overland House LLC in response to the hearing examiner's decision granting a rent reduction application regarding a faulty bathroom and kitchen sink, as well as maintenance of the property's outside common area. A decision was issued which, in relevant part, granted the rent decrease application as follows: $7 for the issues relating to the bathroom and kitchen sink, and $50 relating to the back outdoor common area. Therefore, relevant to this appeal, the hearing examiner awarded a $7 rent decrease for the unit and a $50 rent decrease for the common area for a total of $57. Regarding the sinks, the hearing examiner stated that the evidence shows that the tenant prevented entry for the repairs of the kitchen and bathroom sink. The hearing examiner noted that a landlord's maintenance responsibilities may be modified if it is found that the failure to perform their work or restore the housing service was caused by an intentional act of the tenant. However, the hearing examiner opined that this exemption does not apply to this situation, and so therefore the hearing examiner looked toward the regulation and recognized that the regulations permit a hearing examiner to consider relevant factors when valuing a rent decrease. And the hearing examiner found that due to tenants' refusal to permit landlord entry into the unit to perform inspections and repairs, the lower amount of $7 was selected. And this $7 would be combined for both the bathroom and kitchen sinks. Regarding the condition of the backyard, the hearing examiner found that at the time of the hearing, it was in violation of the municipal code and therefore a rent decrease was warranted. The hearing examiner determined that based upon the amount of vegetation, the code citation from the city, and the ongoing nature of the property, a rent decrease of $50 was warranted. Landlord appealed and claimed that the decision is clearly in error and not reasonably supported by the findings made or the evidence in the record. Staff finds that there is substantial evidence in the record supporting the hearing examiner's decision regarding the common area backyard, and that the decision should be affirmed. Staff believes that the hearing examiner erred in granting a rent decrease for the bathroom and kitchen sinks and should be reversed as the record lacks substantial evidence supporting a rent decrease. Regarding the condition of the backyard, the hearing examiner correctly identified that all rental units must be maintained in accordance with all applicable building, housing, and health codes. The hearing examiner also correctly identified that the municipal code declares overgrown, dead, or dying vegetation a public nuisance. The evidence in the record shows that tenant provided landlord with notice that the property was not maintained properly, and landlord did not remedy the issue prior to the hearing. Specifically, the backyard of the property was not in compliance with the municipal code, and this is supported by a citation issued to the landlord by the city's code enforcement on July 28th, 2022, which was a day before the hearing. And staff finds that the valuation of $50 is reasonable. Regarding the sink, staff finds that despite the hearing examiner finding that tenant intentionally prohibited landlord from entering the unit to perform the necessary repairs, they still awarded a rent decrease. Staff finds that the hearing examiner erred and the record lacks substantial evidence to support such a rent decrease. A tenant cannot prevent the landlord from making necessary repairs while also receiving a rent decrease. Such a result would be against the RSO, unequitable, absurd, and establish a precedent that the rent decrease may be awarded even when a landlord is willing and able to make the repairs, and staff will defer to the staff report regarding analysis of why the hearing examiner erred. Therefore, staff recommends adopting Resolution RSC 22-620. You as the Commission have the power to affirm, reverse, modify, or remand the appeal decision of the hearing examiner. The Commission reviews the hearing examiner's decision under the substantial evidence standard, which requires the Commission to make sure there's substantial evidence that reasonably supports the hearing examiner's decision, is credible, and of solid value. If that evidence is found, the decision must be upheld, even if there's also evidence that could support a different outcome. The Commission does not substitute its judgment for that of the hearing examiner or reweigh evidence. And as it relates to questions of law, the Commission applies an independent or de novo standard of review to the hearing examiner's conclusions of law. Thank you.
Thank you, Mr. Natalizio. Commissioners, are there any questions at this time? Yes, Commissioner Maggio.
Legal counsel, on page 72 in the analysis, the examiner makes reference to West Hollywood Municipal Code section 1756.010B specifically, which says all appliances provided by the landlord, including but not limited to heating devices, air conditioners, plumbing, refrigeration, stove, elevators, washing machines, dryers, dishwashers, shall be maintained by the landlord, so they are all in good working order. It doesn't make any reference to sinks, and to me that is very specific.
The hearing examiner was equating plumbing in this situation, which is identified in subsection B. If the Commission disagreed with that, that's up to the Commission, but that is how the hearing examiner evaluated it.
Also, these we're using West Hollywood Municipal Codes when these are really, they should be West Hollywood Municipal Ordinances, which of course are different from the regulations. I just wanted to point that out. That's all I have.
Thank you, Commissioner. Other commissioners? All right, nothing at this time, Mr. Natalizio. So we are going to hear from the parties, and with that, I'm going to open oral argument for the landlord or their representative to come forward to the podium. And sir, please state your name and the city of residence for the record. You will have 5 minutes, and please indicate if you wish to divide your time between the presentation and the rebuttal. Or if you'd like to take the whole 5 minutes at once, it's up to you.
I'm going to keep it short and sweet. Thank you guys for your time and coming out. I mean, I'm Jonathan Haruni. I reside in West Hollywood. We are the property owner. I'm not the property manager. He was unable to make it, but I'm involved and I know what's going on. We bought this property, didn't want to give anybody a hard time. It came to my attention that the sink or some issues were not working in the unit. We tried to enter, we cannot enter. It kind of makes it difficult to fix anything. We're not tenant doesn't want to cooperate. There's not much we can do. Vegetation came to our attention. Sounds like our maintenance crew was not doing a good job. As soon as it was brought to our attention, I thought it was fixed. And if it's not fixed, we could fix it, just want a second chance. And really, that's it. I mean, anything tenants need from us, we have a good track record. This is our first property in West Hollywood. I am more used to the city of Los Angeles, but we'd love to grow in West Hollywood, and whatever it takes, we're here to do it. So as long as tenants cooperate with us, we have many forms of communication, and we're here to help. So thank you for your time.
Thank you, sir. Commissioners, do you have any questions to the landlord? Nothing? Vice Chair, yes, please.
Yeah, I saw in the evidence that the tenant requested 24-hour or 48-hour notice, for any work that needs to be done or any entry into the apartment. So were you able to provide that?
To my knowledge, yes. And I think it's clearly stated here that if a tenant refuses for us to enter, it's going to make it tough, And I respect everyone's living space. I understand. I know the building has, it's an older building. So we're actually in the process of, fixing it up. We're going to remodel it and do all the things that need to be done to make it look beautiful again. And like I said, I mean, we're not repeat offenders. Someone tells me one time, hey, clean the backyard or whatever it may be. And people make mistakes. So if my maintenance crew wasn't doing a good job, I was made aware, and we're going to take care of that. So,
great, thanks. You actually answered the question. Thank you. And also, is your maintenance person on site for set hours or just as needed?
So they will go by. There isn't that much greenery there, but they'll go by like once every 2 weeks, and if something is needed urgent, they'll be there. We're always around the area. So.
Okay, thank you.
Thank you.
Thank you. Sir, I have a question.
Yes.
I see that we have, as part of our record exhibit submitted, there are 2 24-hour notices to enter the unit. I'm not sure if this is the tenant or landlord exhibit, but were you the one who issued this? Has at least your phone number, Jonathan? But are these notices issued by you?
By the property manager.
By the property manager. So, but have you seen these notices?
I haven't seen them, I would say, with my own eyes, but I'm very involved with the property manager. We know the protocol. I mean, we are, like I said, texting tenants, calling tenants, whatever it may take. So
one notice is issued on February 24th of this year, and the other notice was issued on May 4th of this year. Do you know, if you recall, any other notices were given?
I don't know, but I will say there have been multiple attempts to try to get into there and remedy the situation, and it's been unsuccessful, and we're just
all right.
Kind of tough.
Do you remember when the first time the tenant submitted the request for the bathroom and the kitchen sinks? Roughly.
I don't remember the first time, but
if you don't remember, that's fine.
Yeah, I don't remember the first time.
Yeah, the only thing is that the 24-hour notices, both notices, although they were issued to gain entry, but for the first notice, the reason for the entry was not checked, and for the second notice, the inspection is checked. It's just my observation. All right.
Okay.
If there are no additional questions for the fellow commissioners, sir, you may have a seat. And since you did not wish to divide your time, so this will conclude your presentation. You will state.
Thank you for your
testimony.
time. Thank you.
Thank you, sir. With that, I'd like to invite the tenant to the podium.
Hello, Argelia Kramer, 605.
Can you speak up? Can you speak to the
Yes.
microphone?
Hi, Argelia Kramer, 605 North Suite, sir, apartment 4.
Okay. So please come close to the microphone so we can hear you well.
So I am here to testify that I have.
Before you begin, so you will have, as I said, 5 minutes,
Okay.
and you can start your presentation now. I mean your oral argument.
You can pull the microphone closer to you, too. There you go.
Okay, thank you. Back in December of last year, I sent him a text. I said, I have a problem with my sink. It's the sink processor is a machine. I can't think of the name. It's not working. No, I sent him a text. I said, I just saw a rat go into the kitchen. Can you please send somebody that can close the hole? He did. The next day, the guy was over. While the guy was there or earlier, I said, you know what? The sink is also clogged. Can he check it? Can he fix it? What's wrong with the sink? Sure, okay. Jose comes the next day. He did come. He did the inspection. He looked at it. He said, okay, well, let me talk to Jonathan and, get his permission to come back and fix it. I said, okay, great. Never came back, kept texting with Jonathan back and forth. Nothing happened. He just, everything is written down pretty much. I'm trying to go by as fast as I can in 5 minutes. Mr. Jonathan Rofim, which he is the manager that you see in all the letters, gave me a 24-hour notice to come into the apartment, I believe in February with some other gentleman at 8:30 in the morning. I wasn't able to respond to him quick enough, so I wasn't expecting him to show up. And even if he did show up, it would have been okay. But Mr. Jonathan Rufim, I woke up to him banging on my door and trying to open my door with literally the key that he had in my door. And I was just like, okay, what's going on? I let him in, and he did the inspection, which was a Ziploc bag. He touched the ceiling, which is that cotton ceiling, and he scraped some ceiling stuff into the bag. And he said, we're checking for asbestos. I'm like, oh, okay, well, what about the sink? Nothing. From there on, he went upstairs to the second floor, and he did the same thing, and then he left. Sink didn't get fixed, nothing came back, texting back and forth. Then I just, I got a letter to buy out from him, and I started putting one and two together, and I'm thinking, I don't think his intentions are to fix my apartment. I think his intentions are to get me out, as the other tenants also have, left. I refused, so here I am. It took for me to file this claim with the city, because I want the city to be aware of my circumstances that's going on in my property. There's also other gentleman. I don't know who he is. I never seen this gentleman behind me. There is another gentleman, Ariel, I found his name to be, that called the cops on me while I was in front of my house because he said that I didn't belong there. And the cops came and ID'd me, and they did that twice to me. So thank you very much. I just want to make sure that the city knows what's going on, and that's that's it, I think. Any questions?
Okay, so that concludes your statement.
5 minutes. Thank you.
Now, commissioners, do you have any questions to the tenant? Yeah, please come back. I want to ask you. You mentioned at the beginning. When was the first time you requested the bathroom and the kitchen sinks to be repaired?
It had to be back in December of last year.
December of
2021.
So, and this February 24, 2022 notice is the first notice when 24-hour notice to enter the unit, was it as a result of your request? Do you recall that?
Before that, Jose came literally the next day after I texted him.
Okay.
Jose, which is their handyman, came and he looked at the problem, in which I told him, and he
And
said,
Jose is the maintenance guy, or
that's what they say,
Okay.
yes. Jose is the handyman. I've seen Jose in the property a couple of times. He does work and stuff. So yes, so that was Jose. And then after that, it was Jonathan Rofin with another gentleman. I don't know his name. They did come in, and he did tell me that we're going to come in for an inspection. I thought it was an inspection for what I had requested. I was so upset of the morning rush that was going on that I was just in my pajamas, literally trying to cover up as
Okay,
these men
so-
are coming in my house.
Yeah, you
So-
answered. So briefly,
Yeah.
what was the reason why you denied entry to the unit?
So after this, he kept telling me that, oh, we got to come in for. I didn't deny. He kept saying that he was going to keep coming in for inspections. I kept saying, Jose did an inspection. You came back, did an inspection. Now another inspection.
No, but these notices were specifically issued on February 24th, 2022, and May 4th, 2022.
Yeah.
When you received these notices, on that day, I'm sorry, they're dated February 2023, 2022, and May 2nd, 2022, to again enter the next day or the day after. So did you deny entry after you received these notices on those dates? The entry date for one notice was February 24th, 2022, and the other one was May 4th,
I do
2022.
remember being specific with him that if he was going to come in, it was going to be for repairs. I didn't want him to keep coming in for inspections. I kept asking for what? Inspections for what? And he just wouldn't tell me.
Okay.
I said, please, if you're going to come in for repairs, please, yes. That wasn't the case.
All
Just
right.
kept
So
saying,
you didn't know if these are for inspections or these were for the repairs?
he wouldn't tell me for what inspections, and he wouldn't tell me for repairs.
Okay. All right. That concludes my questions. Thank you.
Then I have one.
Commissioner Maggio.
Can you please explain one more time why the sheriffs were called in?
I like to kind of exercise in front of the building. It's just an area of space.
Yeah, I would
And Ariel Rofin, which I don't know if he lives or what he does, he said he was the manager. None of these gentlemen have ever introduced themselves to any of us, so I don't know who they are.
I would say this is irrelevant for the purposes of this appeal.
Yeah.
Commissioner Maggio, with all due respect, I apologize, but let's stick with the issues that were discussed
Yes.
at the hearing. Any further questions, Commissioner Maggio?
I have none.
Okay, other commissioners? Commissioner Kurpis.
One question. You have a copy of the what we have, right? The staff report and all that. Is there? I wasn't able to find any evidence that you that refuted that you wouldn't allow anybody into the apartment, that you refused them to come in to fix it. So if you have evidence that you presented and we're just maybe not seeing it, could you maybe point that out to us? Was there a letter? Did you respond via text? Because basically we're looking at a situation where the hearing examiner gave a rent reduction for a repair that wasn't done, but in the hearing examiner reported that not only does the evidence show this, but that you also admitted that you didn't allow access to the sink. So I guess what I'm asking for is your help in trying to find out where is evidence that you told the hearing, or that you showed the hearing examiner that you actually were open to having them come in and fix
I'm
it.
gonna get my phone.
Okay. Or is that all right?
Commissioner Kerpes, if she needs a hard copy, there's it's up there.
Yeah.
The appeal packet's on the table.
All the exhibits are in the packet, so you need to look there, because if there's any additional information, we'll not be able to receive.
Yes, okay, so I think I started backwards. Sounds like, okay, yeah, so I did.
And just for the tenant, I think that has both appeals. This case starts on page 66 of that book.
And Commissioner Kirby's, page 118, there are some text messages that are around the date of that May 2nd notice. It's like 118, 119, and I think 120.
Angelia, okay, so that was that. Management can buy left a notice. There is one that I can remember of, but I have to show it to you. When I was specific and I said, no, I don't want you to come in for any more inspections. I need you to come in and fix my sink. He said he was getting tools.
But I think
It's kind of all over
my
the place.
question
I'm
is,
sorry.
is there somewhere that you could point to us that says that you were welcoming them into, like that, yes, this time, this date, I understand that there were a variety of reasons why you might not have let them in for a certain reason,
Yeah.
but what I'm looking for is where you've said yes, that they can come in, and they didn't show, or...
Oh, they didn't show?
I mean...
Okay, so there's this one right here that says, I just saw it. Oh, that he was supposed to come in and he didn't come, Jose was supposed to come and he didn't show up. Did you see that? I just saw it.
What page are you looking at?
Just saw it. I'm sorry. Hope you feel better. This is kind of all over the place. I know mine was high. Okay, so it says, hello, everything okay with Jose? It says Monday, August 1st.
Can you tell me what the bottom of the page number is? In the
Oh, no,
packet?
that was after the hearing.
Oh, okay.
That one's after here. Hold on, I'm sorry, that's August. Really? February 23rd, 28th. December. Okay, so he's here. This is all over the place.
Yeah, so that's the challenge that I'm having is I'm not able to find any evidence. I mean, for the life of me, I don't understand why you would report a problem or something that needs to be fixed, but then also not allow somebody into the apartment. But the hearing examiner, and what I can see, found that there was no access granted, and so that's what it's difficult for me to say you did when I don't have any evidence saying that you did allow, or that you did allow somebody in, or you would have.
Yeah, there's plenty of times that he said, did Jose show up? Did Jose contact you? Jose contact you? And I would say, no, he's not. Just let me know whenever you know he'll come. And in the morning, there's text here that says, I prefer in the morning, so if you can do that, thank you very much.
Okay. Yeah, I did see some of those.
Yeah, you know, like where's anything. And then if he requested to come in, it had to be that time in February that he came in to do the asbestos inspection. So from December to February, there was nothing set. There was nothing, I'm coming. There's nothing, I sent someone.
Okay.
Up to that time. And so then that was the first inspection letter. And then the inspections requests kept coming, and I'm thinking, okay, well, how many inspections do we have to go through this? So I hope that answers your question, but...
It does. It helps me understand the
Yeah.
context of what the situation was.
Yeah.
Thank
so
you.
That's,
Thank you.
yeah.
Thank you, Commissioner. All right, I don't see other commissioners having questions. You may have a seat. And thank you. Well, that concludes the oral argument portion of this appeal, and we can, if we have any questions at this time, we can address to the legal counsel. Otherwise, if no questions, we can start our deliberation. If anyone wants to begin.
Sure.
Commissioner Martz, please. Thank you.
Yeah, thank you very much, Chair. I'll keep it short and sweet. I think the evidence is very clear to support upholding the hearing examiner's decisions. I think as to the question of blocking access, I mean, there's mountains of text messages that show that there's a level of hostility there to not allow people in, whether that's, for whatever reason, valid or not. Well, it's not valid, but if you felt it was valid, that you didn't allow access in for people. And I've worked with and met way too many landlords in my day, and this one seemed like he was trying to make an effort and to follow the law. And I mean, what our job is to say whether the hearing examiner, there's substantial evidence in the record to support their decision. I think there is. In the hearing examiner's decision on page 5, when asked by the hearing examiner if she allowed the owners or any of their representatives into the unit to address the issues raised, specifically the sinks, Ms. Kramer admitted that she has not allowed owner or representatives in regarding the sinks. That's pretty clear to me, plus the text messages that we've read. I think everyone agrees that the outside common area was done correctly, but I would vote to not uphold the hearing examiner decision. I will revise that to follow the staff recommendation regarding, because I don't think there's any reason to give any money on the sink issue, so I think we should cancel that out.
Thank you, Commissioner. Commissioner Wright?
So in looking at the text messages that were on page 118 through 120, I guess primarily on 120, where the tenant says that it looks like she's texting, the landlord, I suppose, where she says, "You don't have my permission to enter the apartment. Don't send anyone. There is no inspection needed." And then looking back at the two exhibits, the notice to enter where it was entering for an inspection, I think the only sort of remaining question, which I don't think either of the parties could have answered, was sort of why the hearing examiner, sort of saw this evidence and saw those notices, and still came to the opinion that, a rent decrease was valid. And for me, I suppose it comes down to the reading of what the code says. And if the code doesn't have stated in it that essentially, that the, I forget what it says, I'm trying to remember the exact wording, but something to the effect of that a specific provision doesn't apply, and so that because that exemption doesn't apply to the landlord in this situation, where if the tenant prevents the landlord from being able to enter, that still doesn't apply to that specific code where this exemption would be warranted. I think it's more of an issue with the code than it is with the decision. And since the code is sort of specific about, what can and can't be considered, I think, I'm inclined to agree with the hearing examiner. And if there's an issue with the code, then I think that that's something, that we can discuss if, some remedy for that, so that way it's sort of not there to prevent it. But if it is, as stated in its current state, then I think, I would want us to uphold that and uphold the hearing examiner's decision.
Thank you. Commissioner Kerpis.
Yes, so I would disagree with that. I mean, I was confused as to why the hearing examiner could possibly come up with the decision that to award a rent decrease when it's regarding a repair when the landlord doesn't have access to make the repair. I can't. I guess I'll rely on staff's analysis here when they, and I'll let staff correct me if I'm wrong, but they cite the case that basically says the language of a statute should not be given the literal meaning if doing so would result in absurd consequences that the legislature did not intend. And I think that this is a clear case of that, how could we possibly expect the landlord to pay for if we are agreeing that no access was given, how could we possibly come to the conclusion that a rent decrease is owed? Because rent decreases, again, are not punishment. They are simply to, the landlord always has the option to either pay the decrease or fix the problem, in most cases, other than health and safety or building codes. But so that's, I just don't, I'm very confused as to how the, even with the logic that the hearing examiner provided, I was still surprised that they came to that conclusion. And so I will be voting to support the staff recommendation to uphold the hearing examiner's decision on the outdoor communal areas, but to not uphold the dollar amount or the decrease.
Thank you. Commissioner Maggio?
Is there substantial evidence supporting the hearing examiner's determination regarding the bathroom and kitchen sink? Is there substantial evidence supporting the hearing examiner's determination regarding the property's common area backyard? We've already determined that the backyard was in disarray, and it will be rectified, although I think every 2 weeks is really not enough. In regard to the kitchen sink, also, even though it is supported by Municipal Code 1756.010, I am also concerned why a hearing examiner would put an amount on a issue that there has not been access to. How could that be determined? In regard to those statements I've made, I am also going to support the hearing examiner's determination.
Thank you, Commissioner Vice Chair.
Yes. I also support staff recommendation to uphold the hearing examiner's decision on the debris and cleanup in the common area. But I do think that the $7 reduction for the sinks should be removed for the reasons that my fellow commissioners have already stated, that the landlord has been denied access to do the work. I know there is some contention around whether people were showing up, workers were showing up to do work or do inspections, but I consider inspections to be part of the work process. I know a certain amount of time had elapsed and plumbing issues evolve, and if workers needed to come in to inspect to see the current situation, the status of the work needed, possible parts needed, things like that, I have no problem with the workers stating that they needed an inspection, and that's why they needed that access. So I believe that if the tenant wants the work done, they do need to provide access to the the landlord's workers.
Thank you, Vice Chair. I'm going to keep it very short. Also, I'm in agreement with the staff's recommendation, affirming in part and reversing in part the hearing examiner's decision. And I don't believe that $7 for a reduction for the kitchen or kitchen and the bathroom sink should be granted. Clearly, there is enough evidence here to demonstrate that the landlord attempted to conduct inspections and repairs. So yes, I wish the 24-hour notices to enter would have been better described. Would better describe the reason of the inspection or the repairs. But you know, if you don't allow entry to the landlord's crew, you wouldn't know what's, you know, what they're going to do there, inspect, or as the vice chair said, that inspection is part of the repairs. They need to see what needs to be replaced, maybe what parts need to be purchased. So I wish there would be better communication between the tenant and the landlord to resolve these issues, but I see from the text messaging as well the intent to resolve this issue, to fix this issue. So you know, as I said, I believe in the better communication in the future, but for the purpose of this appeal, I don't believe that $7 should be granted, but I agree with the $50 reduction for the other issue. So with that, I wanted to... Would you like a motion? Yeah, but I wanted to make another comment, but just...
I have one more comment too before we go to that. But.
All right. Yeah, and okay, let's hear from you, and then we'll make a motion.
I don't think it's fully accurate to say that she never allowed them to enter. The text message on page 118 looks like it's from the landlord, and he's saying, "Good morning, Jose will be there at 9. I understand we did an inspection about 2 months ago. This will be the second inspection." And so for me, it seems that if they put the notice on her door to enter on the 4th, and that's the one that we have in evidence, and that, you know, they're saying, "Oh, we're coming for another inspection." Meanwhile, she's been asking since about December to have these things repaired, and then the continuation of that text on page 120, the tenant is asking, "Well, why are you entering?" She says, "Entering for what? Question mark. What type of inspection are you doing? Question mark. You should only be entering for repairs or emergency. Proof of either is a must, or else you have no right to enter my premises." So to me, it's not a denial of entry, you know, sort of based on this, because she just didn't want them there or was trying to prevent them. She seemed like she needed clarity as to why they were entering. And based on what we have, it doesn't look like they ever responded to tell her why they were entering. And so she said, "Well, you just can't come in and keep doing inspections when there's no work that's following." And so, you know, sort of looking back at the text message on 118 where, you know, he's responding, "We were there 2 months ago." So they were there back in March. No repairs happened. They put another, you know, entry on her door, and it just says inspection again. Then I would sort of be saying the same thing, like, well, when are you actually going to fix the thing that's been broken since December, instead of continuing to do inspections where nothing's happening following those inspections? Okay. And so again, that's why I agree with the hearing examiner's decision.
Okay, thank you. So I would recommend, if the legal counsel, this is possible for this particular case, maybe we can waive the 6-month period to see if the sinks will not be fixed, so the tenant can refile for this reason.
Sure, that's within the power of the
within
commission.
The power of the commission, of course. So anyone would like to make a motion? And if you commissioners, do you agree with the waiving of the 6-month period? So maybe we can make the recommendation, amend the recommendation of the staff. Anyone wants to make the recommendation?
Can I just get clarity?
I mean, make the motion.
So what we would be passing is, you know, adopting what the staff proposed, but waiving the 6 months, so she could essentially refile tomorrow. Correct. If she wanted to. Okay.
Correct. Yeah.
All right, I'll make a motion if you'd like.
Please,
To
Commissioner Marshall.
adopt Resolution RS 22-620, which is a resolution of the Rent Stabilization Commission of the City of West Hollywood, affirming in part and reversing in part the hearing examiner's decision as to rent for application number D-468 with an amendment of allowing, waiving a 6-month period for re-registration, or refiling, excuse me.
I would second that with a clarification. I heard RSC number 22-620. I have 619, but I just want to make sure. I could be very off.
Are you looking in the, I think it's RSC 22-620.
Okay, great.
Okay.
Then I will second that.
Sure. All right, so we have a motion and the second, a further discussion on motion.
I just had a question. So if, essentially that would mean, you know, if she were granted, you know, after she does the refile, it would only go back to the soonest that she filed as opposed to the current one that we have before us that would go back to her original filing earlier this year. So she would lose sort of that rent decrease amount.
Maybe legal counsel can clarify that.
Right, it'd be from the date of the new application.
The date of new application. Okay, so I just want to make it clear that the commission is waiving that the required 6-month period to refile a new application for rent decrease on the same issue, which is the bathroom and the kitchen sinks in this matter. So we have a motion. We have a second. Sure.
Again, I'm looking at the resolution that we got emailed from Staff Secretary. Is it 619 or?
It is 619. There was a change in the resolution number because we were originally going to have 2 appeals. So this was going to be the second appeal that was going to be heard.
Right, so that appeal was withdrawn.
Yes.
Right, okay. So now the correct resolution number is
22-619.
619.
Yes.
Do you want me to, will you do the correction, or shall I redo this?
Okay, let's well, we have the motion and we have the second. We just corrected the record that the resolution number is 22-619.
I think that should suffice.
Yes. All right, commissioners, thank you. Ms. Secretary, may we have a roll call vote, please?
Commissioner Kerpes?
Aye.
Commissioner Maggio?
Aye.
Commissioner Martz?
Aye.
Commissioner Wright?
No.
Vice Chair Ayers?
Aye.
Chair Topshin?
Aye. Motion passes. Thank you, commissioners. Thank you, both parties present tonight, and we appreciate your oral argument. And if you have any questions, you may remain until the end of this meeting and approach our staff with the questions for additional clarifications if you need. Okay, with that, we're going to move on. We're going to continue with our agenda, which, okay, we don't have anything other new business tonight. And next is items from staff.
I'd just like to thank Commissioner Kerpes for mentioning Assemblymember Bloom's Knowing Your Rights webinar, because I'll be there, and I forgot about it. So thank you. And not only will be there, there'll be breakout rooms for various jurisdictions, and obviously, since I'll be there, there'll be a breakout room for the City of West Hollywood. So any one who wants to attend to talk to me afterwards, please do. Thank you.
Thank you, Mr. Manager. Questions? Any questions? No. All right. So then next will be public comment. Ms. Secretary, do we have any speakers at this time?
We have 1 speaker in person.
All right. Let's state. Let's invite the speaker to the podium. Ms. Secretary, can you state who is the speaker and invite to the podium, please?
Victor, you're invited to the podium for your public comment.
Although, Victor, we recognize you, but please state your name and the city of residence for the record, and you will have 3 minutes.
Good evening. My name is Viktor Omolchenko, and I am a longtime resident of the city of West Hollywood. And I voted, and I know that everybody else, I hope, in this room voted. And I thank everyone who participated in the election. And it's good to see you here at the dais continuing to serve in a city that is 80% rent state or renters in that. I look around and I think we are videotaped. Where are the renters? Where are the landlords? Why don't more people participate in this public process? I'm back to just mention that this case, now that the election season is over and we're all getting back to basics in that, this particular case spurred my interest when I was looking over the agenda. And I thank you for the decision that the majority made with the questions that you had brought up. I was quite confused on why the hearing examiner, based on the evidence, would in any way have even come up with a decrease of $7. It just seems so illogical. And it just seems to me like if this gets out, like this kind of stuff, when it gets out, it kind of looks like government amok a little bit. It may have been that the examiner had to do a reading, an absolutist kind of constitutional reading of the rent stabilization codes or the ordinances that applied. But given the decision that you made, it just seems fair overall, seeing the thing about the not the keeping up of the backyard and the $50 did seem reasonable as a rent decrease. But why the hearing examiner would ever even come up with the decrease of $7 for not fixing the bathroom sink and that when he was not allowed in just boggles my mind. And I just offer to you that maybe we should look at whether it's the code or that section 17 or whatever to not put hearing examiners in these kinds of positions. And this has been going on for several months, and everybody's it's costing the city time and money and booklets and that kind of stuff. So I think you as a commission could work on clarifying things and making things clearer so that hearing examiners are not put into this kind of untenable situation, and then tenants are left unclarified, and then landlords are having to appeal. So I'd like you, as a rent-stabilized tenant in a building that's very well managed, I'd like all of our buildings to be well managed, and I think that we need to work on the code and clarifying things. And I talked with, I look at both sides, and a couple of landlords had called me. They had seen about this, but they didn't come. And they said, well, you know, after a while, maybe after a tenant gets three notices that are proper, maybe then no kinds of hearings should be held. So we're looking at government efficiency and streamlining and clarity in our codes and in our laws. Thank you for listening, and thank you for your service.
Thank you, Victor, and we'll hope to see you again soon. All right, no more public comments, I believe, and we're going to move on to the commissioners' comments. Any items from the commissioners at this time? Commissioner Malchu.
Yes, I wanted to bring to the attention of the commission that I think it's imperative as long as you are sitting here, whether it's a year or 10 years, that you attend an in-house hearing to see how a hearing works. And although if you do attend a hearing, you are not allowed to hear the case here, so you would have to exclude yourself. That could be complicated if we don't have a quorum, but I would encourage each of you to, I have in the past, and I've learned a lot from it, and I think you have, Agassi and Josh. The other thing I wanted to mention for the upcoming study session, which will be next year at some point, and I've talked to the manager about this. But in the past, the city, rent stabilization was initiated in 1985, and here we are 37 years later. We have had the privilege of holding 2 rent stabilization conferences in our own city, And we did invite all the leading rent jurisdictions, East Palo Alto, San Francisco, Santa Monica, and Berkeley, to bring together thoughts and ideas and to actually meet each other and to know that the work we are doing together and how fruitful it is. The second conference invited many other municipalities that did not necessarily have jurisdictions, but they did have some form of rent control. And I think we might want to consider doing that again, to be the leader, which we have been for so many years. And so that is my suggestion, that at some point someone would like to initiate that discussion and talk about the benefits of what a conference would bring to our city and to rent stabilization. Thank you.
Thank you, Commissioner. Good comments. Commissioner Wright.
I just want to thank Victor for making the comment. I think, and also along with sort of what Commissioner Maggio is saying, you know, if we have sort of a working session or set aside time to go through the code and make recommendations to council as to what sort of needs to be shored up. I've made my, I voted the way that I did, not because I think it was right or wrong. I think it's because that's what we have in front of us. And so if there's, a time where we don't necessarily have a hearing, to maybe look at some of these things and see if there's some suggestions that we can make. Thanks.
Thank you. And I agree with that. Yeah, those days that we don't have appeals, maybe we can schedule a discussion or any items that may come up from the commissioners, suggestions for the meeting for discussion. Commissioner Kurpis?
Yeah, I had this actually was a question that I forgot to ask earlier during the staff reports, so maybe you don't have to answer it tonight, but maybe we could get an update at some point on the retrofitting of the soft story buildings throughout the city. I know that was affected by COVID and I think delayed, but I'm not sure what the status of it is now. And then I agree with Commissioner Wright, and just to provide a little bit of background, we've had an amazing staff the last 2 years, however long you've been here, or been in this role, that's been very proactive at doing a lot of that stuff. But we did used to occasionally bring up certain items and point them out. The staff would kind of keep a list, and then we would talk about them later, either as a ad hoc committees or through a study session. So I agree with that too. I just think the staff is doing such a great job. We have less to have to find in the statute.
Thank you. Other commissioners? All right, so I just want to echo what the fellow commissioners have said. And just one request, Ms. Secretary, maybe for reduction of housing services cases, maybe we can have the guidelines kind of printed and available, because I always have a hard time to look up on my devices, and I don't want to, in front of a camera sticking on my phone, people might think that I'm, doing some other things. So it would be great to have it, because every time we obviously want to compare to see the numbers, although the legal counsel always includes the ranges, but we want to see if the guidelines in whole. Thank you for that. And since there are no further comments from the commissioners, we're going to adjourn this meeting, and I'm going to read it. The next meeting of the Rent Stabilization Commission will be a special meeting held on Wednesday, December 14th, 2022, not on Thursdays as usually. So once again, on Wednesday, December 14th, 2022 at 7 p.m. here in West Hollywood Park Public Meeting Room, Council Chambers. All right, this meeting is adjourned. Thank you, everyone. Have a good night.